Hi everyone, I'm Gianfranco Peluso, a PhD student at the University of Napoli Federico II, and I'm going to briefly present my poster on the legal framework for ensuring trustworthy AI in the workplace. We will explore both European and national regulations and see how they use the principle of transparency to achieve this goal. In this way, we will also highlight some problematic issues. At the European level, the main regulation is AI Act. I say main regulation because we should also mention the GDPR for data protection, as well as the directive on platform work. Anyway, as we know, the AI Act adopts a risk-based approach, and as illustrated in this image, the principle of transparency is emphasized for both limited and high-risk AI systems. Specifically, the regulation defines systems used in recruitment and workforce management as high risk. I want to highlight three key provisions. The first is Article 13, which states that high-risk AI systems must be designed and developed to ensure that their operation is sufficiently transparent to enable deployers, in our case the employers, to interpret a system's output and use it appropriately. The second is Article 26, which requires employers to inform workers and their representatives before putting into service or using high-risk AI systems at the workplace. Finally, Article 86 gives any person, we can refer to as any worker, the right to obtain clear and meaningful explanations from the deployer, in our case the employer, about the role of the AI system in the decision-making procedure. At the national level, in 2022, the Transparency Decree anticipated some provisions of the AI Act, and in some ways it has gone further. The Italian provision clarifies that the information obligation of the entirely automated decision-making or monitoring systems must cover a range of detailed aspects, such as the purpose, objectives, logic, and functioning of these systems, as well as categories of data and main parameters used to program or train them. However, there are limitations in the case of industrial and commercial secrets. From the above, at least two problematic issues arise. First, it is necessary to clarify the relationship between the broad notion of AI systems under the AI Act and that of entirely automated system. Second, the transparency principle, specifically the obligation to provide information and the right to explanation, is often limited by the black box nature of many AI systems. This requires combining knowledge to understand, from a legal perspective, how the principle of transparency should be applied, including determining the meaning of concepts like interpretability and explainability, as provided in the mentioned regulations. Thank you.